John RAPANOS wanted to build on his Michigan cornfield in the late 1980s. He never imagined it would cost him years of litigation and land him in federal prison. All this because he moved some sand on his own private property.
Well, let me tell you what this case is about. At one level, it's about federal power to regulate wetlands. At another level, it's really about civil rights. Pacific Legal Foundation is in this case to vindicate Mr. RAPANOS' right to be free from illegal and heavy-handed federal regulation. We also hope to vindicate every citizen's right to be free from arbitrary government action. And we wish to affirm the bedrock constitutional principle that there are limits to federal power.
We are standing in what they say is a wetland. There's no fill here. We're standing in a cornfield, and you're facing what both in the criminal case and the civil case they say is wetlands, right here in front of us, from here to the Labadzinski drain, both the criminal and the civil case. And you can see here that this goes downhill into that county drain that was dug 100 years ago. And they accused me of digging that ditch. Well, when he was told, this expert for the government was told, RAPANOS didn't dig that, that's a county drain, he said, well, then this couldn't be wetlands. And he was not allowed to come back the next day. The EPA fired him.
The federal government is saying that they can regulate anything that's connected hydrologically to a navigable water, a traditional navigable water, a water on which you could float a boat. If even one molecule, one drop, or a trickle of water flows from point A to a navigable water, it's subject to federal control. And in this case, we're talking about a trickle of water that's running from 20 miles away. And according to the federal government, according to some courts, it doesn't matter whether this a trickle of water is flowing over a foot or 100 miles. It's the same.
We're really looking at is federal jurisdiction. And when Congress passes laws, it's not up to federal bureaucrats or any kind of government employee to decide that they want to pursue the law in their own fashion. They're supposed to follow the intent of Congress.
Russell Harding was the Department of Environmental Quality head for the state of Michigan from 1994 till 2002. And he came out here and he examined all of the criminal case where they said was wetlands, and he also checked all the civil case areas where they said there was wetlands.
The federal government was asking to put him in prison for 5 to 10 years for moving sand on his property. And so I got involved, and I actually visited the property on a number of occasions, and I dug probably 50 or 60, I know well over 40, I'd have to go back in my notes, but I dug well over 40 holes to determine if I could even find any wetlands on the property, and I had never once could even discover any wetlands on the property.
The trial judge thought that they were going overboard, that the prosecutors had a personal vendetta against him, and the judge particularly noted that the Constitution is designed to protect individuals just like Mr. RAPANOS.
They've accused me of filling this property with 302,000 cubic yards of dirt. That would be 30,000 trucks, 10-yard trucks, 30,000 trucks in 29 acres. In 29 acres. And it would be this high if it was true.
The federal government could not present a single witness that could say that any dump trucks were hauling all of this fill into this property at which the federal government alleged was covering this cornfield. Certainly, it should have been easy for the federal government to have witnesses if that many thousands of dump trucks running literally 24 hours a day is what it would have taken to move that much fill, and they couldn't produce that. But nonetheless, they still prosecuted.
Because there were no bona fide areas that fell under the jurisdiction of the Gomar-Anderson Act, there was no reason whatsoever that Mr. RAPANOS should not have been able to do just exactly what he did. and be legal in doing it.
The property we're standing on, I bought from the state of Michigan. After they had mined sand here, and then they built a ditch through there, which I got accused of digging. The state of Michigan dug it. You know, there was no problem then, there's no problem now. There are no wetlands then, and there's no wetlands now.
Irregardless of anyone's view on the protection of wetlands, this is very important in terms of protecting citizens' private property rights. And it's important that federal bureaucrats can't make up the law as they go.
There are over 100 million acres of wetlands nationwide that could be subject to federal control. This is one case that has the potential of definitively determining what the scope is of the authority of the Corps of Engineers and the EPA to regulate remote wetlands.
I think they're harassing me, they're harassing my family, they're trying to break me and break my family. It just isn't right. Somebody has to stand up and fight the federal government on this illegal grabbing of people's property.
Why this case is so important is when the federal government asserts jurisdiction, it leaves property owners in a position where they absolutely can't even determine if they're breaking the law.
At this time, with this case before the Supreme Court, Mr. RAPANOS is not on trial. The federal government is. The question here is not what Mr. RAPANOS did. The question is what the federal bureaucrats did. Did the Corps of Engineers, EPA, exceed their authority in regulating these wetlands which have no material, significant nexus with the navigable water? That's the question.